So, welcome everyone to the 2025 Labor Law Update. Today sponsored by the City of Glendale, who you'll be hearing from in just a second. My name is Anna Manzano, and I'm the Digital Media and Event Strategist here at the California Employers Association, and we just want to thank you all for joining us live today. Before we officially get into today's training, I have just a couple details to go over with you. So as you see, your audio is muted for today's presentation, but there are going to be lots of opportunities to engage during the training, just like you're already doing so in the chat. And if you have any questions about the content, you can put those into the Q&A box at any time. So if you're on a desktop computer, along that bottom row of buttons, you'll see Q&A. That's going to be the best place to put your question, because as one presenter is delivering the content, one will be monitoring that Q&A. I will be present in the chat, dropping in links for you and watching out for any technical difficulties. You'll see a PDF pop up in a second. So best place, if your question ends up there, it's fine. I'll just ask you to copy it over into the Q&A box, because then people know where to go to see what questions have been answered as well. Handouts for this training were sent out in the reminder email coming from City of Glendale team. But what I'm going to do is also drop them into the chat box shortly. I know we had a flurry of people registering for this, so I want to make sure everyone has access to that PDF. So in a moment, you'll see that file name and icon pop up in the chat box. If you just click it, it'll download locally to your drive. And again, I'll be watching that chat in case you have any technical difficulties accessing it. Just ping me and I'll make sure I get it to you one way or another. We do have a recording that will be going out. So again, since City of Glendale is sponsoring today, I will send them the recording file by end of day. And then once that is made available to you, then they will reach out to you guys with instructions on how to access that playback. Last but not least, we do have a survey. So because your feedback is incredibly important to us, at the end of today's training, you'll see a slide with a QR code. At the end, when you close out of Zoom, you'll also see a browser window pop up. So you can choose your own adventure, but the browser window will, all it's going to ask you to do is to opt in. So you can, it's a 5-question survey, and it generally takes about less than a minute to complete. So if you could take that minute at the end to provide us with some feedback, we would greatly appreciate it, just to make sure we are meeting and hopefully exceeding your expectations with trainings like this. So again, our training is brought to you by the City of Glendale, as I've mentioned a couple times. And today we are joined by Sevik Deshoyan, who is the Economic Development Coordinator, to share more about the resources available to employers like you.
Thank you, Anna. Hi, everyone. I want to thank you on behalf of City of Glendale's Economic Development Division for joining us today. We're very happy to be working with California Employers Association to bring you those monthly webinars. Given that the topic of today is on California labor law updates, I wanted to highlight one of our core economic development business services that we offer, again, in collaboration with California Employers Association, our free HR hotline. This is specifically designed for businesses and employers in Glendale. So at any moment between Monday through Friday, 8 a.m. to 5 p.m., you can give them a phone call and get all of your HR-related questions answered. So it can be from basic minimum wage information all the way to industry-specific labor laws. In addition to this, also, by the way, we also provide free business retention and expansion services to all businesses in Glendale. So whether it's finding a location for your business, assisting with the permitting process through our concierge team, market analysis assistance, and finally, marketing and social media support. If you'd like to learn more about what we do at Economic Development and how we can help you not only start your business, but also grow it, I would highly encourage you to visit our website at chooseglendaleca.com, or you can contact me. Again, my name is Sevik Deshoyan, and I will leave my information in chat to make it easier for all of you to contact. With that being said, I will now pass it back to Anna to get the webinar started.
Awesome. Thank you, Sev, to you and your entire team at the City of Glendale for bringing this together today, and for always putting together such awesome trainings and resources for employers. So with that being said, I want to introduce our 2 presenters today. We have Eli Nunez, who is an HR director here on the team, as well as Virginia Young, who is our HR compliance director. I believe Eli is kicking us off, so I'll hand it over to you.
Thank you, Anna. Thank you, Sev, very much. And thanks to the City of Glendale for partnering with us and, again, providing this hotline for all employers. So we look forward to hearing from you Monday through Friday, 8 to 5. We are closing some holidays, but for the most part, we're there, ready to answer your questions. Or if you just have any kind of issue you want to talk through, just, you know, you want to bounce it off of somebody, give us a call. We're there for you. A little bit more about us. We are California Employers Association, and what our main goal is to provide employers with peace of mind by providing trainees such as the one you're being a part of today, advice through that 800 number, or even putting out some kind of any kind of printed materials, fact sheets, that sort of thing. Anything we can do to help, basically. We know human resources is complicated. We know the state of California can be complicated, so we are here to help ease the burden on you as a business owner or a business administrator. So again, we're here to help. Give us a call. Having said that, one thing that we are not, and I am definitely not, is I'm not a lawyer. And even though we do have people on our team with legal experience, this training and any other trainings or any other communications we have are not to be considered legal advice. Now, they are here for educational purposes. We'll provide you information, we'll provide you things that the law or regulations say, but we will not give legal advice. If you have any questions of a legal nature, we do advise that you contact legal counsel or your attorney for an answer. They will be better suited to answer that question for you. So with that, we could just jump right into the presentation here. I'll be taking the first half and talking about wage and hour changes for 2025, things like the minimum wage or other wages going up, as well as changes to PAGA and independent contractors. Also, I'll be talking about employee rights. This includes things like captive audience meetings, protected classes, and changes to the ways jobs are advertised. Then I'll hand it off to Virginia for the second half. She's going to talk to you about leave and benefit changes for employees, as well as some safety changes that we saw in 2024 coming into 2025. So a lot of different changes, a lot of different areas, as is the custom with the state of California. So let's go ahead and get started with the first part. And the first thing I'll talk about always, of course, is wage and hour updates. I saw one question in the Q&A already pop up regarding minimum wage, so we'll do our best to answer that for you as well. But thing to keep in mind is that the minimum wage in the state of California has increased once again as of January 1st of this year. We've gone from $16 to $16.50. And again, this goes back to legislation passed back in the Jerry Brown days that stated that once inflation or the cost of living was up beyond a certain amount, then there would be automatic increases to minimum wage. Ideally, these would have slowed down, but we are seeing that those numbers are still a little high. So minimum wage has gone up to 50 cents to $16.50. Now, this is for your non-exempt hourly employees. But this also does have a bearing on your exempt salaried employees. And these are employees such as your managers or administrators, anybody that's paid on a salary basis that are exempt from meal and rest breaks or from overtime. Their minimum compensation also went up to $68,640 per year. Now, the way this number comes about is we take that hourly minimum wage, we double it, and then we multiply it by 2,080 hours, which is the equivalent of a 40-hour work week for the whole year. That's how we get that $68,640. Now, if you find yourself in a situation where you have exempt employees that are not making that minimum salary, you really have two options. You either increase them so they're making at least that minimum yearly salary, or you transition them back to non-exempt hourly employees. Now, this does mean that you have to pay them, hourly. They're eligible for overtime, and they have to go back to taking their meal and rest breaks, along with other things that hourly exempt employees have to do, like clocking in and out and that sort of thing. So again, think it through very carefully to see which way you want to go if you do need to transition someone back. But having said that, if you do have to transition an employee from exempt to non-exempt, it's usually an easier transition because in the state of California, all employees are considered non-exempt unless you as an employer can prove that they are exempt employees. So it's the burden of proof is up to you to prove they're exempt. Otherwise, they are non-exempt. Now, if you do have to transition them from exempt to non-exempt, we do have a fact sheet with some tips that'll help you because there's several things to think about, right? The first one, again, I mentioned overtime, meal and rest breaks, that sort of thing. The other thing is that sometimes employees can consider it almost like a demotion, right? If you're going from salary to hourly, even though we know that's not the case, that could be the impression. So we do have some tips on how to make that transition a little smoother. Besides the minimum wage, we also have to think about local minimum wages as well. So we have the state minimum wage, which is 16.50, and that's the floor, that's the minimum. But Local municipalities can also choose to go higher than that, and several of them do throughout the state of California now. We do have a bit.ly link there at the bottom that you can go to see which areas are affected, but most of them are metropolitan areas, right? Los Angeles, San Diego. I know there's some for Hollywood, the Bay Area, Northern California. So take a look to see if you are in one of those areas or if you have remote employees that work in one of those areas as well. Because remember, if you have remote employees, the laws apply to them where they are performing the work. So for instance, if you are in an area that is governed by a state minimum wage, but you have remote employees that work in somewhere else with a higher minimum wage, or perhaps they have different, more protective paid sick leave or predictive scheduling or flex time laws, you have to abide by those laws for that employee. So again, it is where their place of work is located. That is where the laws and the protections apply to them. The other thing to keep in mind is if you're in an industry where your employees travel to different areas, such as construction, landscaping, housekeeping, that sort of thing, you have to abide by the minimum wage and other protections where the work is being performed. So keep that in mind. Again, it's where the employee is physically working. So be aware of where your employees are working, or if you're sending your employees to other locations to work, be aware of what the laws there are to make sure you're compliant. Now, aside from the state and the local minimum wages, we also have a couple that are related to specific industries. The first one that I think we all heard about was a fast food minimum wage that came into effect April 1st of 2024. Now, that basically stated that employees in a chain restaurant with over 60 locations nationally had to be paid a minimum wage of $20 per hour. And this was clarified by the state to tell us that it also affected any exempt employees in those fast food restaurants. So exempt employees will also be subject to a new minimum wage, which was $83,200 per year. Obviously, a big leap from the state exempt minimum wage, but this is based on that $20 per hour hourly minimum wage as well. There was no increase as of January 1st, but the Fast Food Council does have the ability to meet and recommend working conditions and minimum wage changes each year. So again, this is going to take place until 2029. And even though there weren't any changes in January 1st of this year, um, keep an eye out for it. There may be additional changes mid-year, depending on what that Fast Food Council decides and recommends. So if you subscribe to our blog, if there's any changes, we'll make sure to get that word out to you as well. There is also another minimum wage effective for healthcare workers. And this one's one that bounced around a little bit last year. I believe it was first supposed to take effect in May, but it was delayed a couple times due to the financial situation of the state of California. It finally took effect on October 16th of 2024. And this one is more of a tiered increase in minimum wage. So it depends on a couple different factors, including the size of your organization or if you're part of a larger medical group. Now, it doesn't apply to all offices across the board. There are some exceptions to them. So you want to make sure that if you believe you qualify for one of those exceptions, contact legal counsel just to make sure that it applies to you. Now, the goal of the healthcare minimum wage is to get employees up to $25 per hour. But again, the first tier, the first range of them is from $18 to $23 per hour. There is another increase expected in June 1st of this year. No word yet on what that could be. So keep an eye out for that if you are in the healthcare field as well. And of course, this also does affect exempt employees in these fields. So exempt employees, to maintain their exemption, must earn either 1.5 times the healthcare minimum wage or 2 times California's minimum wage, whichever is greater. So again, take a look to see if and which one of these applies to you, and then make sure you're calculating that exempt minimum wage correctly so you don't basically so you don't get in trouble for paying your exempt employees incorrectly. Something else we saw change, and this is a yearly tradition, as you will. The mileage reimbursement cost has increased as well. Now, this is established by the IRS. This went up from 67 cents per mile up to 70 cents per mile. And this applies when employees use their own vehicles for company use. So if you have, say, you ask one of your employees to maybe go pick something up or go to the post office or go deliver something for you and they use their personal vehicle, you should be compensating them accordingly. Now, the 70 cents is what the IRS estimates is the cost for fuel, wear and tear on the vehicle, um, insurance, etc., etc. It does not include the wages for the employee. So if you have an hourly employee that's driving their personal vehicle, you should be compensating them their hourly wages plus 70 cents per mile. As an employer, you can pay less than that, but then the burden will be on you to prove that the lower amount adequately covers all those expenses. So if you're going to pay anything less than that 70 cents per mile, which is what we recommend paying, if you're going to go anywhere lower than that, be ready to defend the reason why you're paying less than the IRS recommended amount. Now, some good news for employers, I guess, is there was some reform made to PAGA in the state of California. And this is by a couple bills. That's AB 2288 and SB 92, which were signed into law. And these basically reformed the Private Attorney General Act. Now, I say these were good news and not great news because for a while they were considering just doing away with PAGA altogether, but at the last hour, this was a deal that was struck between the legislature and some business groups to reform PAGA and keep some version of it around as it is now. This isn't completely retroactive, so it doesn't go back to existing cases already. It only applies to any PAGA cases filed on or after June 19th of 2024. And the changes really affect what an employer can do to help kind of mitigate the claims against them or the damages against them. So basically what this new reform does is it tells employees that they can take reasonable steps to show that they are trying to avoid making any of those mistakes that would usually fall under PAGA claims. So some of the steps that they can take are doing periodic payroll audits and then correcting or taking action with according to their findings, having written policies, lawful written policies that protect employees and the organization as well, of course, and then providing their supervisors with training. You know, anyone in business knows that sometimes it's those supervisors that are dealing with your employees on a day-to-day basis that can make or break you, right? Sometimes our mistakes kind of or kind of affect the whole organization. So, you know, providing them training and documenting that training is something that you can do to help mitigate those claims. And the last one is taking corrective action if you find any supervisors that are not following your policies. In other words, if you have policies in place and you show that you are enforcing them adequately and fairly across the board, as well as, you know, towards any supervisors that are breaking them, then if there is a PAGA claim against you, you can show that, you know, you've taken some reasonable steps to kind of try to correct it before it happened. Now, penalties for PAGA are capped at 15% if all the reasonable steps were taken before the notice of employee request for records. So in other words, if you get a notice of request for records and you can show that you were already taking these steps before that that notice was sent and received, then you can cap your total penalties. Now, if the actions were taken within 60 days of receiving the notice, it caps at 30%, and then, you know, so really that can really help with the amount of penalties for you as an employer. Finally, you know, the reform also changed the share of penalties that go to the employee from 25% to 35%. So again, you know, it's good news because it shows that if you take the right steps and take action to try to correct some of these issues before they happen, it can help you down the road. Next change we had relates to independent contractors and more specifically freelance workers. And this was SB 988. And basically it applies to freelance workers that perform professional services as an independent contractor. In other words, it's somebody that qualifies as an independent contractor. Now, this doesn't change the ABC test that we use in California to determine who an independent contractor is, but rather extends protections for those basically those one man companies or one man show, right? Or one person shows, the ones that basically would just be one person performing one service for you or anything like that. So some of the requirements or some of the protections that are extended to them now are similar to what you would do if you're contracting with a larger organization. So you have to have a written contract with specific information on there, and it also protects the independent contractor from any coercion or any changes once the agreement has been entered upon. So this could be things like reducing their compensation or asking for more goods or services after that, as well as providing them with retaliation protection. So really this SB 988 really expanded the independent contractor protection to freelance workers. And some of the workers it applies for would be people in marketing, HR administration, graphic design, freelance writers, certain appraisers or professional foresters, to name a few, estheticians as well. So if you contract freelancers in any of the fields shown, take a look to make sure that you are following the bill and having a written agreement, having all the correct information on there as well. All right, so some to-dos now for wage and hour for 2025. Make sure that you are paying the correct minimum wage, of course. And if you do have to make any adjustments, make sure that you're documenting those. Now, you have those wage theft notices that the state provides us. Make sure that you are providing those to any employees whose wage rate changes. Now, if you are operating in any municipality with a higher minimum wage or specific minimum wage, or if you have remote employees in those areas, make sure that you're paying them correctly as well. And if you have any exempt employees, take a look at them to make sure that you are still paying them the required minimum salary to maintain that exemption. Finally, if you do have any independent contractors or freelancers that you use, make sure you're following the correct arrangements. And most importantly, take those reasonable steps to help mitigate any PAGA claims. Now, to help with that, we have put together a wage and hour audit PAGA prevention package available in our store that you can use to guide you in your audit for wage and hour to make sure that you're compliant and to help show that you are taking the steps to mitigate any of those issues before they happen. So let's talk about employee rights and protections and what changes we are seeing for 2025. The newest one is the EEOC harassment guidance. Now, the Equal Employment Opportunity Commission has updated their guidance after nearly 25 years. And the way they updated it was they added 77 new examples and clarifications. So some of the highlights of these are they've included intrusive questions about sexual orientation, gender identity, transition, or intimate body parts as a form of harassment, denying a person of the LGBTQ plus workers, denying them access to bathrooms consistent with their gender identity or intentionally repeatedly misgendering them is considered harassment as well. Sexual harassment can be based on pregnancy, childbirth, or any related medical conditions. And it can also occur in remote work environments. Now, we're having a discussion about this offline about how basically the work world has transitioned to very remote, right? We have these trainings remotely, we have meetings remotely. So be very aware that harassment can occur in those environments as well. And it also basically fleshed out what we call intersectional harassment, which means that somebody can be harassed based on more than one protected characteristic. So, for instance, someone could be harassed based on both their race and their age, or their gender and their age, or that sort of thing. So, it's not just specifically one thing or another, it could be a combination of factors that lead to harassment or discrimination. FEHA, the state of California, already had some of these measures in place. As California offers ample protections, usually more than the federal government does. But there was some amendment by FEHA, that's SB 1137, to recognize the concept of intersectionality or intersectional discrimination. And again, this just basically specifies that harassment or discrimination can be not just because of one protected class, but a combination of two or more classes. So, for example, you could have somebody, an example we always think of is if you have a female employee that is older and she mentions that she forgot something or that she's been absent-minded lately. If somebody tells them, oh, well, it's that happens to a lot of women that are going through menopause or something along those lines, then that comment or that discrimination or harassment can be based on her because of her gender, but also because of the age groups. That's a combination of more than one factor that leads to unwelcome or insulting comments in that example. So thing to do with this is make sure that you update your handbook or your employee harassment prevention policies to make sure they address the concept of intersectionality in them as well. Another change we saw that came through was SB 1100 or SB 1100, which deals with driver's license discrimination. And basically, what this law states is that we cannot require a driver's license on a job application or a job advertisement or posting unless it is basically an essential job function. So, unless you expect driving to be a function of the position and you believe an alternative transportation will not be comparable in time or cost. So, as an example, us here at California Employers Association, we frequently go on site to our member locations either to conduct trainings, conduct audits, or help with investigations. And we travel throughout the state for these functions. So you can reasonably assume or reasonably say that an alternative mode of transportation such as Uber or Lyft or something like that would not be reasonable for us to use as transportation. However, in comparison, if you're hiring somebody to be maybe a receptionist or a front, front of room person at a restaurant or something, and they tell you that they do not have a driver's license, that really has no bearing on whether or not they can perform their job if their job is to be on site. So you have to be careful when you are requesting that driver's license and make sure that if you're requesting that, it is an essential part of the job. Otherwise, make sure you review your applications, your job description, your job postings to make sure that request for that information is not on there. All right, next thing we saw was SB 399, which relates to captive audience meetings. And what this one states is basically gives employees the freedom to decline attending meetings or listening to communications from their employer regarding their opinions about religious or political matters, including labor organizations. So this means is that if you have an employer want to have a meeting with your employees to tell them how you think they should vote or to tell them your thoughts on organization or labor unions or that sort of thing, your employees can choose to decline to attend that without any adverse action. So in other words, you can't write them up for not going. And on top of that, employees should be paid for the time of the meeting that they chose to not attend. So basically, I mean, this kind of goes along with some of the NLRB's rulings, saying that mandatory captive audience meetings are unlawful. But just be very careful if you have these types of meetings, or even if your supervisors or managers tend to have meetings, whether they're formal or informal, where they touch on these subjects. So again, just be sure that you're not covering areas that should not be covered at work. Now, top of that, we do have some updates to your labor law posters, which, as happens year after year. So in this case, we have the first one relates to the whistleblower protection posters. The new poster has some guarantees. Um, Basically, that fulfills the requirements. Obviously, minimum wage has changed, so the minimum wage poster has to be changed. We also have the workers' compensation poster that had some changes on it, including stating that the employees have a right to consult an attorney and that attorney fees will, in most cases, be paid from the employee's recovery, as well as having an updated DIR notice. And then the Civil Rights Department has a new discrimination harassment poster, as well as family care and family and medical leave and pregnancy disability leave posters. So best practice, I mean, make sure you're updating your posters every year. If you do it yourself, make sure you're getting the right ones from the right agencies. Otherwise, you can just get one of those all-in-one posters. We do have one on our website, employers.org, for you to purchase. You can get it either on paper, laminated, or if you have a lot of remote employees, you can get a virtual version that you could put on your server, on your drive, so employees can access it at any time. Now, some to-dos for employee rights, things to keep in mind. Make sure you stay up to date on your harassment prevention training. That touches with that EEOC's new definitions or new examples. So that training is every 2 years. Make sure you're on that cycle. Make sure if you have new hires, you train them pretty much upon hire. We recommend make that a part of the onboarding or orientation process so that they are up to date on their harassment training. Make sure handbook policies are updated regarding protected classes. Again, these things change every year. There's always updates, so make sure that you're keeping up with it. Make sure that your handbook reflects these changes. Take a look at your job postings and applications to make sure that they're not requesting a driver's license for employees unless it is an essential part of the job. Train your supervisors on captive audience meeting law. Again, make sure your supervisors are not touching on subjects that they really shouldn't or that could get you in trouble, giving their opinions or having mandatory meetings to talk about politics, organized labor, religion, anything like that. And finally, update your labor law posters for 2025. Now, again, as a CA member, we do provide free harassment or access to free harassment training online for staff through CA University, so keep that in mind. And with that, that brings us to the halfway point. Going a little fast today, but we do have a lot of material to cover, so I will stop sharing here and give Virginia a chance to jump on and take over the second half for us, or see if we have any open questions on there. Looks like we have a couple. If you
We do
want,
have
I
a
can.
few, yes.
Yeah, I could jump on those as soon as I jump in the background if you like. So, and again, make sure you stay up to date with those harassment trainings. I mean, that's going to help keep you out of trouble. If there's ever a claim, that's going to be a great defense. So with that, I will turn it over to you, Virginia.
Great, thank you. So picking up where Eli left off, we do have a lot to cover today. We're going to talk about a couple of new laws that affect relating to leave and benefits that will affect California employers in the new year. The first one is AB 2499, which basically amended the laws protecting employees who are victims of certain crimes. And just a brief refresher for what the law was before January 1, 2025, all employers in California are required to provide reasonable accommodations for employees who are victims of domestic violence, sexual assault, and stalking in order for them to seek relief in court for their own safety or the safety of their child, such as getting a temporary restraining order. Additionally, all employers are required to provide reasonable accommodation for employee safety at work, which can include things like transfers, installing locks, assisting employees with documenting issues that come up at work relating to the crime, reasonable accommodation standards. And these are requirements that have always applied to all employers. And with these requirements comes the requirement of confidentiality on the part of the employer, meaning that the employer needs to, only provide information on a need-to-know basis to management and law enforcement. So AB 2499 made some amendments to these laws. Most specifically, they provided, they brought the enforcement of these laws under the jurisdiction of the California Civil Rights Department, the same agency that enforces the Fair Employment and Housing Act. Prior to 2025, the Labor Commissioner enforced these laws. So changes in 2025 is a new definition of victim, which we'll get to on the next slide, a much broader definition of who can be a victim. Another major change is that the reasonable accommodation requirement that I was talking about a minute ago now applies either when the employee is the victim of the crime or when their family member is the victim. So that's important to remember. It's also important to remember that employees can now use paid sick leave for all crime victim purposes. And one thing that all employers will need to make sure is on their calendar is the new notice requirement relating to these rights. There will be a new notice published on or before July 1st of this year by the Civil Rights Department for employers to give to their employees relating to their rights under these laws. Employers have to provide employees with this notice when they're hired and anytime the employee requests protections under these laws or informs an employer that they or their family member is a victim. But a new requirement is to give this notice to all employees annually. This means that, whether or not the employee has requested the leave, sorry, I moved the slide forward, whether the employee has requested the leave or not, you need to provide the notice annually. And I got back to that first slide just in time to finish up. The duty to provide this notice does not begin until the state agency actually posts the notice on their website. So that is something that we will be looking for and that you should be looking for as well. I mentioned before that there is a new definition of a victim. The prior definition was very strictly tied to the crimes of domestic violence, sexual assault, and stalking, as well as physical injury and death of immediate family member. It's a broader definition now, a qualifying act of violence, which can include all of those things, but also any crime where bodily injury or death to another individual, any crime that involves exhibiting or using a firearm or other dangerous weapon, or when there is force used to cause physical injury or death. I mentioned before also that the definition of a family member is important. A family member is basically defined the same way as it is under the California Family Rights Act, and includes the child, parent, grandparent definitions, as well as the designated person concept. This means that every employee can designate an individual either related by blood or an equivalent to a family relationship that can be considered a family member for purposes of these protections. Employers can limit the employee to one designated person per 12-month period. If you have 25 or more employees, you have additional time off requirements when employees are crime victims. And those include things like seeking medical attention, victim services, mental health services, and safety planning. There are some new reasons for leave in 2025 that if you are a larger employer of 25 or more employees, you'll need to be aware of. Employees who are victims or whose family members are victims can now take leave for things like finding a new school for a child, for preparing for legal proceedings, as well as caring for their family member who is a victim or providing child or dependent adult care. A couple of things that this changes to the law did provide that are helpful to employers is it provided clarity in how an employer can limit the amounts of this leave. They can limit it to a total of 12 weeks. The leave can run at the same time as your California Family Rights Act leave. However, you can limit the leave even further when it is the family member who is the victim. And unless the family member is deceased as a result of the crime, the employer can limit the leave to 10 days total or 5 days when it's used for relocation or finding a new school. So there's a lot going on. It's a complicated law. It's technical. You will likely need to update your employee handbook policies, look for that new notice, and just be aware that there have been recent changes. Another change in the law that isn't quite so nuanced and complicated is a change to the paid family leave benefit program for 2025. The paid family leave benefit program is run by the EDD, and it provides wage replacement benefits, partial wage replacement benefits to employees who miss work because they are caring for a sick or injured family member, or for bonding with a new child, or under certain circumstances relating to a family member's military service. Under the old rule, employers could require employees to use up to 2 weeks of their accrued vacation before receiving these benefits. But under the new rule, employers are no longer allowed to require employees to use their vacation or PTO. So you should update your handbooks and make sure that your staff who is administering leaves of absence and employees who may be applying for these benefits, make sure that they're aware so that they are processing their paid family vacation use during these times properly. Another update to benefits is really a reminder about the CalSavers program. The CalSavers is a retirement savings program for employees in California who do not have a plan at work. And employers who are not exempt from CalSavers, have to register and provide their employee roster so that those employees can elect to participate in the CalSavers state-run retirement program. The employer has to facilitate this participation by making payroll deductions and providing them to the state. What's important to remember about 2025 is that the end of 2025 is the deadline for employers of at least one employee to register for CalSavers unless they're exempt. If you're a larger employer, you may recall that there have been phased-in deadlines for larger employers to register with CalSavers, but 2025 will be the last year. So one employee or more, you need to check out CalSavers, and if you're not exempt, make sure you register by the end of the year. So just a quick update or a summary, I should say, of the leave and benefit to-dos. Do update your crime victim policies and your other policies that might be affected, such as your sick leave policy. Do prepare for the new notices under the crime victim leave law. Do update your leave practices in light of the new paid family leave law changes. And if you haven't registered for CalSavers or made a determination that you're exempt, now's a good time to do that. If you do need assistance with any of these things, we can assist you with those, including your employee handbook. So please keep us in mind for that. And moving on, we'll talk about some health and safety updates for 2025, and specifically the Workplace Violence Prevention Standard, as well as a new indoor heat illness standard. Both of these Cal OSHA standards went into effect in the middle of 2024, so they have been in effect for a few months. But for those of you who weren't aware of them in the middle of the year, it's important that you are aware of them now. Let's see. The Workplace Violence Prevention Standard required employers to establish written workplace violence prevention policies. California had formerly had a workplace violence prevention standard that was applicable to the healthcare industry. That is still in effect. It's been in effect for many years. But now the workplace violence prevention requirement has been extended to basically all employers with very few exceptions. It's a Cal OSHA standard. You have to have a written plan that needs to be reviewed and updated each year, and your staff needs to be trained on it each year as well. So what do you need to calendar? There are ongoing requirements for your California Workplace Violence Prevention Program. You need to have an annual review of your workplace violence prevention plan, and this will include soliciting employee feedback, having periodic hazard inspections over the course of the year, and having safety meetings are also highly recommended. So all of those things will need to go into your annual review of your workplace violence prevention program, and your training of your employees also has to be on an annual basis. So be sure you schedule all of these things on your calendar, and if you need assistance with that, CEA has a do-it-yourself workplace violence prevention package available at our store at the link here on this slide. So it sounds like a lot, but it doesn't have to be, and it does have ongoing requirements. So it's definitely not something that will collect dust on your shelf. The next requirement that Cal OSHA requirement that went into effect in 2024 is the indoor heat illness standard. The indoor heat illness standard applies, basically there's been an outdoor heat illness standard applicable for many, many years. Employers have had to maintain, who have employees who work outside, have had to maintain heat illness prevention plans. Now the focus of the indoor heat illness standard is on any kind of indoor place of employment. It's not where the temperature may reach 82 degrees or higher while employees are present. So this standard is aimed at things like warehouses and restaurant kitchens, food trucks, generally speaking, places that don't have full working air conditioning. It's not limited by industry. So it's the temperature that is important, not necessarily the industry you're in. And as for what the definition of an indoor place of employment is, pretty much if it has 4 walls and a ceiling, it is an indoor place of employment. So a shed, like I said, a food truck. So what do you have to do if you have an indoor place of employment that may reach these high temperatures? The main requirements, well, first of all, you need a written plan, a written heat illness prevention plan. And essential requirements include water has to be available to all employees working in these environments. And you have to allow them frequent cool down breaks, time to drink water. If you're providing bottled water as opposed to plumbing water, it has to be free, and you have to have at least a quart for every hour for each employee. You do need to train your employees and supervisors specifically on the signs of and dangers of heat illness. You have to develop emergency response procedures. You have to make your supervisors aware of, in the event of a heat wave where the temperatures are more than 10 degrees higher than the average for a period of 5 days in a row or more. Your supervisors will need to be trained on how to acclimate employees to the increasing heat. And if you have an indoor place of employment with extremely high temperatures, you may be subject to the high heat requirements when the temperatures or heat index exceed 87 degrees, or as low as 82 degrees if your employees are wearing very restrictive clothing, such as head-to-toe clothing to protect them from chemicals or things like that, or if you have employees who are working very close to a high heat radiant source, like a big stove. If you do have if you are subject to the high heat requirement, the additional requirements are basically you're going to have to consider engineering and administrative controls to lower the heat. And you are going to have to keep track of the temperatures and keep records of the temperatures and the heat index. So that's something to be aware of, something to develop another written plan on, and make sure you're compliant with. And both of those standards, the workplace violence prevention and the indoor heat, went into effect over the summer. So if you're not yet compliant with those, that's something to be on top of now. So we are also saying goodbye to, we've said hello to a couple of new OSHA standards, and one is sunsetting this year, and that is the COVID-19 non-emergency regulations. Those will sunset on February 3rd. However, the record-keeping requirements associated with those to keep records of your notices and things like that to employees will continue at least another year. So we encourage you to continue compliance with record keeping and to continue to monitor Cal OSHA's website for any changes. We do have the link at the bottom of the page you can use to check out Cal OSHA's latest updates on their non-emergency regulations. There's been no indication that the expiration date of February 3rd will be extended at all, but do keep an eye on it. So safety to-dos, make sure you comply with the workplace violence prevention and training requirements on an annual basis. That's going to have to be a regular part of your safety program. If you need to develop a heat illness prevention plan, either for indoor or outdoor employment, you should get that going. And then as I mentioned, monitor your COVID-19 requirements and continue with the record keeping. CEA does have a number of safety partners, the Safety Center, Safety Compliance Company, and Shaw Law Group. And they are listed on our slide below. You can call us if you have any questions about that. So what is next for California employers? Be sure that you stay up to date on your trainings, and this can include your mandatory harassment prevention training, which is required every 2 years for employees. You also need to be aware of your annual workplace violence prevention training, and you should also, we encourage you to do supervisor wage and hour training so that you can take advantage of the PAGA reform that Eli was talking about earlier. Do keep your employee handbook current with new laws, and CEA can assist you with this. Remember the new minimum wage requirements Eli discussed at the beginning of the presentation, paying particular attention to any local ordinance requirements or industry-specific requirements if you're in the fast food or healthcare industries. Labor law posters definitely have changed for 2025, so make sure you have the updated posters, and please do stay tuned to CEA for ongoing developments by following our blog. The CEA does have several membership packages which allow at all levels unlimited HR phone support, online access to our toolkits and forms, many of which we've mentioned here. All members also receive access to CEA University with its on-demand harassment prevention training. And we do have different levels of membership, as you can see here. If you need more help or want more assistance, we do have HR Assist programs if you want some dedicated assistance from one of our HR business partners, help with day-to-day operations, training and onboarding, and just a different level of support. So if that is something of interest to you, please feel free to download our flyer about our HR Assist program at the website here. And with that, I would like to thank the City of Glendale for sponsoring this hotline, and I will turn it back to Anna for some housekeeping matters.
All right. Thank you, Virginia. Thank you, Eli, for sharing your time and expertise with us. I know we zipped through that, my friends. So we still have a couple minutes that you have us for. So if you have any lingering questions, at this point, whether they end up in the chat or the Q&A is fine. So if you want to throw those into the chat or Q&A, please do. You have direct access to our amazing trainers right now. I see a question from Nova about a recording. So yes, let me start over. This training is sponsored by City of Glendale. So what I will do once the video is available to share with them, I send them the file. And then once that is available on their page to share, they will notify all of you who have registered for this how to access that playback. So definitely make sure that you are on their list. Seb, I believe, is still online with us, and he will make sure that you guys get that information.
I dropped the link in there for CalSavers as well. I know there are a couple questions popped up, so they do have an FAQ on there, and they have the option there in the guidance so you can enroll for it as well.
Perfect. Razmi, please forgive me if my pronunciation was wrong, but the laminated posters for 2025, if you hop into the Q&A, I know Eli popped the link to our CEA store, or maybe he can find that for me real quick.
Gotcha.
Actually, I can. I've got it right here. I don't know.
Beat you there.
Let's see who can get there first.
Already there.
You're so good. See, I can't talk and link at the same time. This is why we divide and conquer here. Okay, so if Virginia or Eli wants to bring up the slides, I do have some codes for you all if you are joining us for continuing education credits. Again, we'll see who gets there first.
All right. She got it.
As we're navigating to that page, this again, the PDF was dropped into the chat at the beginning. I know we had a few people joining in late, so I'll drop that PDF into the chat shortly. But if you are joining us for continuing education credits, it's in the chat as well. HRCI code 690616, SHRM code 25-Q94DX. As our friend Eli always says, whatever you do not forget the dash. If you have no idea what to do with these codes, please reach out to us, ceainfo@employers.org. You can also reach out on the HR hotline in the slide that's in that PDF, which again, I'm going to drop into the chat because I know we had some people join us potentially after I dropped it in there. So there is coming to the chat right now. If you click it, it'll download locally to your drive. I think.
Question floating out there about CalSavers. Can out-of-state employees participate as well? And from CalSavers website, it says out-of-state employees can participate if they are residents of California and meet the eligibility criteria. So we're not exactly CalSavers experts, but again, that's what CalSavers has to say about out-of-state employees participating.
Perfect. And with that, I believe that brings us to the end. So I want to thank Virginia and Eli again for sharing their time and expertise with us, answering all these amazing questions. Thank you all for bringing your amazing questions and for remaining so engaged with us. In regards to, I believe it was Hannah that asked this question about the workplace violence package. I am getting that resolved by end of day, so I have your information and I will reach out to you and I'll share it with Seb as well to let him know that it's been updated. So thank you for bringing that to my attention, and we will definitely get that updated for you all. Apologies for any confusion there. And I thank you, Seb, and the entire team behind the scenes at City of Glendale for bringing trainings like this to employers like yourselves, and we look forward to seeing you on the next training. Thank you all.